I think we're now ready to resume. Mr. Fitzgerald.
Yes, my Lord Reed put to me that in the Steinfeld case, there was no question of a lex specialis, and I of course accept that that's right. Although of course there was in the close case, the Northern Ireland Court of Appeal case, that's an appropriate moment perhaps to turn to section 14 and the lex specialis point. My submission is that applying the Steinfeld approach and applying the close approach, then in the absence of section 14, there would clearly be a violation of section 9 taken in conjunction with section 16, just as there was in the Steinfeld case and just as there was in the close case. But the question is whether section 14 operates to preclude such a conclusion in this case. The Court of Appeal primarily relied on the proposition that section 14 is the lex specialis and that it governs all issues concerning access to marriage under the Caymanian Constitution. And the Court of Appeal found that this precludes reliance on any other sections of the Constitution that found the appellant's right to marry, and that it expressly rules out any right on the part of same-sex couples to access the institution of marriage. I did take the court to the key passages there at paras 93 to 98 of the Court of Appeal's judgment, at 166 of the electronic bundle to 167, and then again at paragraph 105, electronic bundle 169. But our submission is this: if you're looking at the special provisions, you're asking yourself, what are the special provisions that govern the appellant's situation? It is not self-evident that the answer is section 14 and section 14 alone. It all depends on the conceptual level at which you characterize the problem. There seems to be a certain amount of interference. I'm so sorry, Reynolds.
I think, Lady Arden, you may have your. It's sorted now.
Oh, I'm so sorry. Okay, right. Okay. Well, so it does depend how you conceptualize the problem. Looked at from one point of view, the issue here is just as much about respect for family and private life, just as it is in connection with the right to found a family, which no one's disputing that same-sex couples have the right to found a family, and that their right to found a family is not located in section 14.1. And it's just as much about equal access to an important state institution as it is about the right to marry and found a family. So we say, actually, this case is, in substance, in reality, about discrimination. The discrimination being sharpened by the fact that there is now civil partnership acknowledged. And the question is it discriminatory then to accord civil partnership to same-sex couples, but marriage also and civil partnership to different sex couples? Is that discriminatory? We say Steinfeld and Close would indicate that it is. And we do respectfully invite the court to look at the way we dealt with the linguistic issue at 3.5 of our case, and page 702 of the electronic bundle. It's a point about the language in which one conceptualizes the issue. This is not about the appellant seeking to establish a right to same-sex marriage or a constitutional right to same-sex marriage, or to establish a new institution of same-sex marriage. As said there, the appellants simply wish to marry. they wish to enter the existing institution of marriage, which has been part of the common law since time immemorial. They want to access that national institution, in the language of the Obergefell case. And that point was made in Fury at paragraph 35. If you go to electronic bundle page 1244, and so electronic bundle page 1244, and the point that is made at paragraph 35 is the primary issues should be granted access to the existing common law institution of marriage, and that was the issue. And if one looks at Obergefell also, can I just take you to Obergefell at tab 18 and to Obergefell at page 1378. They make the point that, and this is at the top of page 1378, that the government, the respondent government was saying, the petitioners are trying to establish, I quote, a right to same-sex marriage. But in fact, as they make the point, this is not about a right to same-sex marriage. And they make the point, Loving, the case about interracial marriage, did not ask about a right to interracial marriage. Turner did not ask about a right of inmates to marry. Zablocki did not ask about a right of fathers with unpaid child support duties to marry. Rather, each case inquired about the right to marry in its comprehensive sense, asking if there was a sufficient justification for excluding the relevant class. And so we say this isn't, if you say this is about the right to same-sex marriage, of course that's a convenient shorthand. But if you say this is about the right of same-sex couples to have the same rights as other sex couples in relation to a major national institution, and this is about the prohibition on discrimination on grounds of sexual orientation in section 16, it is not so self-evident that the lex specialis is section 14 rather than section 16. It all depends on the conceptual level at which you characterize the problem. And we've set out, against that background, our essential case in the written case at part 5, that's at electronic bundle 714. So taking the approach that one should strictly interpret any provision which is purporting to take away rights, the obligation in section 41 is binding on government. Government shall respect the right of every unmarried person. Now, it's true that the same language is used in section 9, but that actually makes our point. This is not about the invention of a right, but about the duty of the government to respect it. So it doesn't create the right and define its ambit. It requires the government to respect a pre-existing right, a historic right, of every unmarried man and woman of marriageable age to marry a person of the opposite sex. So this is not the Constitution saying these are the only people who are allowed to get married. It's saying that the government must respect the traditional form of marriage and can't interfere with that. But that doesn't mean that another status group.
Lady Arden has a question.
Oh, I'm so sorry. Forgive me, Lady Arden.
That's right. I'm sorry about the muting earlier, and I hope it didn't disturb the argument. But I did want to ask a question now, so I've unmuted briefly to ask it. Isn't it a feature of the lex specialis that although you can point to two sections, articles under which you can bring your claim, if one of them is a lex specialis, then however you conceptualize your claim, you'll be excluded.
Well, my lady, I would respectfully submit not. Firstly, lex specialis is obviously apt in the interpretation of a treaty. I would submit that the interpretative principle of a domestic constitution would be the generalia specialibus non derogant principle. But I accept it's of a similar nature. That's to say that a general right, a general provision cedes priority of place to a special provision. I accept that as a principle of domestic interpretation applicable to a constitution. But my submission is, if you ask yourself, what is the generalia and what is the specialibus here? It's just as appropriate to characterize it as an issue of discrimination rather than an issue of marriage. My lady, I'm not sure that fully answers your question, but I may have just repeated myself in answer to a much more directed issue. But that's how, it depends on the level of abstraction at which you characterize the issue, I respectfully submit it's just as possible to say what is at issue here is the right of people in a same-sex relationship to be treated equally with those in a different sex relationship, as to say this is all about marriage. Everything about marriage is said in section 14, so push off, which is really the argument of my learned friend and of the Court of Appeal, and it is so. The lex specialis argument, which was equally applicable, didn't deter the Court of Appeal of Northern Ireland. My learned friend says because they didn't know what they were doing, but we respectfully submit they did know what they were doing and they were right.
But haven't we got to get down and analyse exactly what makes something a lex specialis in this context, of course?
My lady,
you've done very well. I won't press you on that.
Well, my lady, I accept that the European Court, in the context of what is undoubtedly a principle of international law treaty interpretation, treated it as the lex specialis, and the language is at least closely analogous. But I say that just because the headline above it is marriage doesn't mean that the only applicable section or the only specific section is section 14. I mean, section 14 doesn't address discrimination, so you could say, well, this case is all about discrimination. Where do we find the lex specialis on discrimination? We find it in section 16. Or one could say, this case is all about the right to found a family, right to have a base of founding a family. Where do you find that? It's section 9. That might be, but it's certainly within the ambit of section 9. But my lady, I fear I can't improve on that as an answer.
Your answer was helpful. Because your answer was helpful because there are situations. For instance, let's suppose you have you wish to go through a ceremony of marriage, but the registrar says you're ineligible and you have no right of access to court under the domestic law. Then you would say it's a violation of a right of access to court, despite the fact it's to do with marriage. I just wondered where the line came anyway. So
yeah,
we'll
well, I'm very
grateful out as we go along.
Well, that's a very helpful another example. I'm grateful, my lady. But if we're going to bill the exclusion of a right which we submit would otherwise be there on Steinfeld and close principles and on all the common law principles, I respectfully submit one's got to be very sure that Section 14 really is a lex specialis excluding any right that would otherwise exist. And I submit that it is not so. In our submissions to the Court of Appeal, which the court has, we indicated that lex specialis is typically a principle of treaty interpretation. But I do accept, and I think my Lord Reed gave a judgment about the general principle of interpretation, that general provisions cede to special provisions. But I just don't accept that this is necessarily the special provision that governs this human situation, or the exclusive special provision. And then we've set out our essential approach at 714. So the government has got to respect the particular right. So to the extent that it is lex specialis, this is what the government has got to respect. And it's got to respect that particular right. And at 5.5, we've set out, it requires the government to allow the right to marry to be exercised freely. And it doesn't define an exclusive right to marry. It presumes a historic right to marry and says the government must respect that, just as the government must respect the right to private and family life. It doesn't preclude others from accessing the institution in reliance on other sections in the BOR. And we do make the point, which the Chief Justice made, that if that had been the intention, it could have expressly stated by adding the word only. I mean, that would make it lex specialis, because then you could say, well, the Constitution clearly tells you that all you need to know about the right to marriage is set out in Section 14 because it has the word only there. Then I accept that the generalia would specialibus derogant in that case, so that would well, they could not derogant. At 5.6, we've made the point that it differs in the addition of the words opposite sex, and we've made the point that it's not to marry and to found a family, but to marry and found a family, so that they're conjunctive. And we also make the point at 5.10 at page 716 that the obligation is secured by the modal shall respect. Section 14.1 imposes an obligation on the subject, namely the government, not to interfere with a right found outside of Section 14.1, because it exists at common law already. So we say this doesn't create the right to marry and define its ambit. It acknowledges the need to protect a particular version of the right to marry, the traditional version, and to respect that. That's how we put the case. I do.
I'm so sorry. It may be that your example of writing in the word only is rather helpful, because suppose it had said words to the effect that the right to marry could only be exercised by people living in Grand Cayman and not on any other island. Then one would have said, well, that's discriminatory.
Yes.
And the fact it's lex specialis ought not to come into the matter.
Well, what I would submit there is, that's where my learned friend's reliance on the Mirrorbucks case might come in. She would say you have to take the Constitution as a composite whole, and that therefore, if you have only there, as I understand it, the argument would be you can't use one part of the Constitution to query the constitutionality of another part of the Constitution. But because you don't have only, you don't have that problem. But our Section 16.1 together with Section 16b point is, and that's our fallback position or our alternative argument, that you can still say that a law that is passed in accordance with Section 14.1, therefore imposes a restriction in accordance with section 14.1 falls foul of section 16.1 if it is discriminatory, and this plainly is, and if it doesn't pass the test in section 16.7b, i.e. you test section 2 by saying, what's the justification for section 16.2? So for section 2 of the Marriage Act, what's the justification and authorization for it? They say section 14.1 authorizes it, authorizes section 2 of the Marriage Act. We say you can then test section 2 of the Marriage Act against the combined test of 16.1. Is it discriminatory? Yes. And section 16.7b, is it a restriction in section 2 that is reasonably justifiable in a democratic society? Answer no, for the reasons given by the Chief Justice. So that's our alternative basis.
It might be thought that that way of putting it begs the question. Section 16 prohibits the government from treating any person in a discriminatory manner in respect of the rights under this part of the Constitution. Now, the right under section 14 is the right of a man or woman to marry a person of the opposite sex. That's the right. That's not discrimination in the discrimination in respect of the right. The right is that is what the right actually is.
Well, my lord, again, that's where as it were, there's the divergence between myself and the Court of Appeal and my learned friend, because what we say is that one of the rights in respect of which they're being discriminated is section 9.
Yes, I was only referring to section 14.
Yes. You mean you can't test the section 14, but by reference to section 16.
Well, the point I was making was that you can't complain that the right conferred by. I don't think you can complain that the Marriage Act is discriminatory in respect of the right conferred by Article 14, because the right conferred by Article 14 is itself a right only to marry somebody of the opposite sex.
No, my lord, I accept that. I accept that. So it would have to be the right conferred by section 9,
yes,
or the right conferred by section 10, in respect of which the discrimination. I'd accept that.
Yeah.
Well, that then you have our points at 5.14. It's not Article 12. Caution must be exercised when applying case law on Article 12 to the differently worded section 17. Sorry, section 14. Sorry. It's not a savings clause. It's not an ouster clause. I think that's pretty self-evident. And then we invite the court to take the broad and interpretive approach to the Constitution as a whole, and to give a purposive approach to the scope of section 9 and section 16, such as that their scope is not excluded by section 14. We've referred to the living tree principle and the case of Edwards at EB 719, and that's interesting because if the court would just look at page 720 6.3, there was no doubt that there were lots of words in there which referred to the qualifications of the senator as he or his, i.e. that presumed that it would be a male. And basically, the board took the view that they were going to transcend the extraneous circumstances which belonged to the time at which those words he or his were written in, and to adopt the living tree principle that there must be development. That's at 6.6 in the case at 720, nor am I convinced the reasoning based upon extraneous circumstances we are asked to consider establishes a rule of interpretation by which construction of powers legislative bestowed in general terms is controlled by the presumptive exclusion of women. And they basically adopted an approach that an interpretation that confined persons to male persons based on the references to he in the qualifications of the senator was no longer consonant with modern approaches to the equality of the sexes. And that was really the case which started the whole doctrine of the living tree approach to the interpretation of constitutions, which is cited after that in the Minister of Home Affairs and Fisher, which we've cited at 6.10, and the Attorney General and Jobe, which we've cited at 6.11, and of course Lord Bingham in Reyes, where he is citing the Trop and Dulles test of moving forward in light of evolving standards of decency that mark the progress of a maturing society. And you also have the quotation at 6.13 from the Matthew case, which may, I understand, be coming back to the board as a result of the Caribbean Court of Justice taking a different approach. But one has there Lord Hoffman, who was in the majority, talking about the living tree principle and the notion of the unremitting protection of individual rights and liberties that's cited at 6.13. It's similar language. We did provide you with Bow, and there's just one short passage in Bow, which I should refer the board to, where if I can just give you the passage and read it out, perhaps. It's Bow and the Queen, 2006 One Weekly Law Reports, page 1644 G, and in Lord Bingham engaging in some careful construction, if I can put it that way, to avoid being disabled from giving effect to the modern approach to the inhumanity of the mandatory death penalty, said this: in the final resort, the most important consideration is that those who are entitled to the protection of human rights guarantees should enjoy that protection. The appellants should not be denied such protection because a quarter of a century before they were condemned to death, the law was not fully understood. Now, of course, I accept that the question was a slightly different one, but this idea that one must interpret the Constitution so as to give full effect to human rights rather than to restrict them, and to allow for the evolution of human rights rather than to restrict them, could, in our respectful submission, be adopted as an approach to the interpretation of section 14.1 as something guaranteeing a limited right to different sex couples rather than excluding rights from same-sex couples where they're founded on other sections of the Constitution. And my lords and my ladies, the other point that my learned friend relies on a case called Mirabux, which is set out in her case. I just make this short point in response on Mirabux. Mirabux was a case where there was a separate and comprehensive code for the disciplining of a judge set up under the Constitution. And it was said that that code took priority over any general provisions guaranteeing the right for a hearing to be in public in normal judicial findings. One can see there that there was a discrete code governing a particular type of disciplinary process, the Bellies Advisory Council dealing with a judge who was guilty of or suspected of being guilty of misbehaviour. And it was said that the general provisions guaranteeing a hearing in public didn't apply to that separate and discrete code. That's a totally different situation from this, where it's obvious that what is at stake here is something that in which the rights under Section 9 and Section 16 overlap to a considerable extent with the rights referred to in Section 14. Therefore, one can't say, well, this is an exclusive, separate, marked off code for a particular situation. And so that's how we distinguish the Mirabucks case. Whilst accepting you've got to look at the Constitution as a whole, if you look at the Constitution as a whole, it's an unsatisfactory conclusion to say Section 16, which deals with discrimination, has got nothing to do with this. Section 9, which deals with family life, has got nothing to do with this. The only provision that deals with it is that headed marriage in Section 14. That we respectfully submit is an oversimplistic approach and one that denies rights rather than safeguarding. But my lords, my lady, that's essentially how we put that case, and we have then developed in the written case the provisions about the points about international law and Goodwin, which I will come to the question of Goodwin. Whilst I'm on that, it is necessary to adopt an interpretation in forms of international law. Reliance on international, my learned friend relies on the Jocelyn decision, Jocelyn and New Zealand, which we've dealt with in the written case at 6.18 and 6.19. Perhaps I needn't take you to the decision itself on that point because it's set out fully in the case. So in the Jocelyn case, reliance was placed in 1999 by the the Human Rights Committee of the ICCPR on the fact that there is a reference in the Universal Declaration of Human Rights to men and women, just as there is in Article 12. And it's men and women have the right to marry. If we look at the, perhaps we'd better look at the Furey case on this. If we go to Furey, which is at bundle at 1286. Justice Sachs deals with this point, we say helpfully, about the meaning attached to the words men and women of full age. So if one looks at 1285, the international law argument, Mr. Justice Sachs says, considerable stress was placed by the state on the contention that international law recognises and protects heterosexual marriage only. As such, the state contended, cannot be regarded as unfair discrimination to exclude same-sex couples from the institution of marriage. The remedy to the plight of same-sex couples should therefore be found outside of rather than inside marriage. Thus, reference was made to Article 16 of the 1948 Universal Declaration, which states 16.1, men and women of full age, without any limitation due to race, nationality or religion, have the right to marry and found a family. They are entitled to equal rights as to marriage during marriage and its dissolution. Similar provisions from a number of different human rights instruments were referred to. Support for the argument was sought for the provisions in our constitution requiring customary international law be recognised as part of the law of the Republic, that when interpreting a Bill of Rights, a court must consider international law. And then he makes this point: the reference to men and women, that's in 16.1 of the Universal Declaration, is descriptive of an assumed reality rather than prescriptive of a normative structure for all time. Its terms make it clear that the principal thrust of the instrument is to forbid child marriages, remove racial, religious or nationality impediments to marriage, ensure that marriage is freely entered into, guarantee equal rights before, during and after marriage. And then it says there's reference to the family being the fundamental group. Further down on para 101, there's nothing in the international to suggest that the family, which is the fundamental unit, must be constituted according to any particular model. And then he makes this point: indeed, rights by their nature, paragraph 102, will atrophy if they are frozen. As the conditions of humanity alter and as the ideas of justice and equity evolve, so do concepts of rights take on texture, new texture and meaning. When the Universal Declaration was adopted, colonialism and racial discrimination were seen as natural phenomena embodied in the laws of the so-called civilized nations and blessed by as many religious leaders as they were denounced. Patriarchy, at least as old as marriage systems defended, is no longer accepted as the norm. And then one sees, and then he gives other examples of the way in which patriarchy has been replaced and evolved from. And then at 103, the decision of the United Nations Human Rights Committee is clearly distinguishable. The committee held that there was no provision in the ICCPR which forbade discrimination on sexual orientation. This is a far cry from declaring the ICCPR forbids the recognition of same-sex marriages and sealing off same-sex couples from participating in marriage or establishing families. And then just over the page at para 104, it would be a strange reading of the Constitution that utilised the principles of international human rights law to take away a guaranteed right. This would be the more so when the right concerned was openly, expressly and consciously adopted by the Constitutional Assembly. Now, the point that we would respectfully make is his point about the assumed reality, men and women. You can't read the words in Article 12 of the European Convention or Article 16.1 as saying men and women rather than men and men or women and women can get married and only them. In fact, and this is the only purpose of putting the article in that we discovered over the weekend, it's made clear by Professor Paul Johnson, who is a sociologist but has conducted the background research, that in his article, that the reason why they put men and women in the Universal Declaration, the reason why it was then replicated in the European Convention, was to stress that both men and women had an equal right to be married. It was nothing to do with excluding same-sex couples, which wasn't really an issue in 1950. And so the European Court in paragraphs 54 and 55 of Shout make this big thing about men and women means that it's not men and men and not women and women. In fact, the reason why the expression men and women was introduced in the first place is almost certainly just as a matter of common sense, because the concern to stress that women had an equal right to be married as men did. So one of the pillars of the argument put that, oh well, they don't use people or persons, they use men and women, is actually undermined by careful research and actually undermined by common reasoning about what would have been the concerns in 1950, which would have been equality of the sexes rather than to rule out same-sex marriages. But we do make the point that the reasoning of Justice Sachs about the Jocelyn case and about the meaning of UDHR is helpful. The assumed reality or the particular concern should not be used then to exclude other rights for the future. So that's the submission we respectfully make about Article 16.1 and indeed about Article 12, because in Schalk and Kopf, the European Court says it was a deliberate choice to use the words men and women in Article 12. But in fact, that wasn't to exclude same-sex marriage. It was to ensure that women had equal rights to marriage. Can I just give you the references in the article that we would particularly say are particularly helpful? It's at page 217 of the article about the point of Article 16 of the Universal Declaration, page 220, and then at the bottom paragraph of page 221 of the article, and the conclusions at pages 223 to 224 about what were the reasons for Article 16.1 of the Universal Declaration and Article 12, Article 12 of the European Convention. We respectfully say that actually a moment's reflection shows that is the most reasonable interpretation of why the words men and women were used. As to still on the interpretation of section 14.7, section 14.3 is relied on by the Court of Appeal and is relied on by my learned friend. And it's relied on the basis, well, if you had same-sex marriage, it wouldn't be governed by section 14.3 because 14.3 refers to nothing in any law done on shall be held to be contravened subject to the extent that the law makes provision is reasonably justifiable. Well, there isn't in fact anything in subsection 3 which refers exclusively to a heterosexual couple. But in any event, let's assume that the right is founded on section 9. If you go back to section 9 at page 855, there is equally a provision that one can make restrictions on any right founded on section 9 under section 9.3 if it's reasonably justifiable in any democratic society. So that would cover all the type of restrictions provided for in section 14 subsection 3. And equally, if one looks at section 16, one can see that there is subsection 7, which allows for restrictions as long as they're reasonably justifiable in a democratic society. So we say 14.3 is not an answer to our submission that you can found a right to same-sex marriage on section 9, because section 9 itself allows for reasonable restrictions on the exercise of that right, which could be entirely analogous or directly analogous to the kind of restrictions provided for under section 14.3. So I come finally in this regard to the way that the Court of Appeal relied on the lex specialis principle. The Court of Appeal relied on Schalk and Kopf and on Oliari, and we accept that in Schalk and Kopf, and this is at electronic bundle page 1575, there is a lex specialis type reasoning. So it says EB 1576, 101 of Schalk and Kopf. Insofar as the applicants appear to contend that if not included in Article 12, the right to marry might be derived from Article 14 taken in conjunction with Article 8, the court is unable to share their view. It reiterates that the convention is to be read as a whole, and its articles should therefore be construed in harmony. Having regard to the conclusion reached above, namely that Article 12 does not impose an obligation on contracting states to grant same-sex couples access to marriage, Article 14 taken in conjunction with Article 8, a provision of more general purpose and scope, cannot be interpreted as imposing such an obligation either. And our answer to that is because the European is that it doesn't really apply to our situation here. The European Court had contemplated that Article 12 might one day be the medium through which a right to same-sex marriage was recognised. And they did that at paragraph 62 and paragraph 61, saying it's not, Article 12 is not in all circumstances limited to marriages between two persons of the opposite sex. So they were saying you could have a right to same-sex marriage founded on Article 12. And what they were saying is, if you're going to do it at all, you've got to do it through Article 12, which allows for that, rather than Article 8. And the same is true in Oliari, where they, at paragraphs 193 to 194, at 1510, where they repeat that point.
Mr. Fitzgerald, just before we move away from Schalk paragraph 101,
yes,
I mean, the point you made doesn't feature at all there, does it? I mean, the point of paragraph 101 seems to be, since there is no obligation on states to recognise same-sex marriage under Article 12, and Article 12 is the specific provision, therefore one can't read in such an obligation by way of Article 8 and Article 14. There's no step in the reasoning that says, well, one day it might be done under Article 12.
No, well, my lord, I accept that that is not spelt out. I'm just saying, if you read the judgment as a whole, they clearly are contemplating at paragraph 61 that time it's not inapplicable to say. But my lord, I accept it isn't expressly spelled out, but I do. It is a special provision, Article 12, that could yield a right to same-sex marriage, according to the ratio in Schalk. Whereas,
well, just on that, maybe not. All that can be said for certain is it doesn't now.
Yes, my lord, I accept that. And then they say, well, you can't. But my lord, we seek to turn it on its head, if I can put it that way. And it may not be a complete answer, but what we say is, given the use of the additional words of the opposite sex in Article 14, sorry, Section 14 of the Caymanian Constitution, Section 14 could never address the situation of a same-sex couple wanting to get married. Therefore, it's got to come from outside Section 14 if it's to be recognised at all. That dilemma didn't face the European Court because they had acknowledged at paragraph 61 that the right of a same-sex couple to get married could eventually be catered for under Article 12. So, my lord, I agree that I'm supplying a step in the reasoning which isn't spelled out there, but I do submit that it's not an unreasonable way of approaching the judgment as a whole.
Yes, thank you.
So, my lord, that's the first argument. But if I can go on from that, the right to found a family, which is in section 14.
Mr. Fitzgerald, I wonder if, before you go on, if I could raise a point with you.
Sure.
You recognize the existence of the words a person of the opposite sex in section 14 as a novelty compared with Article 12.
Yes.
You made your submissions on its effect. You've referred us to Paul Johnson's article about the origins of the reference to men and women in relation to the Universal Declaration. Is it legitimate for the board to look at the negotiations to understand what the drafters of this constitution were trying to do?
Well, my lord, first of all, we do draw a distinction between there's treaty interpretation principles which say that as a matter of international law, you can look at the travaux preparatoires of an international treaty to see what the various nation states discussed amongst themselves. That is not directly analogous to the various groups who are chosen to get together and discuss the drafting of a constitution. So there is a distinction. But my lord, Chief Justice Chaskelson, in the case of Macriniana, did say that if the negotiation process was clear and there was an uncontrovertible, you could have regard to it. But it's got to be clear and incontrovertible before you have regard to it in the interpretation of a constitution. And we say that there are dangers which are highlighted by Benyon about delving into the history and saying this is what so and so thought, and this is what so and so thought, and this is what was discussed. And there's the wonderful quotation from the, I think it's in here, the wonderful quotation from Lord Halsbury saying, I have more than once had occasion to say that in construing a statute, I believe the worst person to construe it is the person who is responsible for its drafting. He is very much disposed to confuse what he intended to do with the effect of the language which in fact has been employed. That's at 4088 of the bundle. Benyon hoists a massive warning signal about saying this is what somebody like Mr. Henry, who's quoted, says he meant or they meant. Therefore, it's what they did mean. And Lord Phillips in Hamza says the statement of a parliamentary draftsman as to the meaning words are intended to bear is not a legitimate aid to construction. So I do say it's clear, there's a big warning about this. To the extent that Chief Justice Chaskelson said that it might be legitimate in a constitutional context to look at the negotiations, he said it was only legitimate if it was clear and incontrovertible. I think it's paragraph 9. And there it was a very simple thing. Why did they leave out any reference to the death penalty in the right to life? And the answer was because they decided it was best to leave it to the courts. Fairly straightforward point. Here, there was a particular provision which was going to be section 16(3) of the Constitution, which would have said you can't rely on section 16 to argue that you have a right to same-sex marriage, and that was omitted. And so if we follow the labyrinth, they say, well, it was omitted because they thought that they had already done the job sufficiently well in section 14 by defining marriage in that way. And I say that that kind of labyrinthine reasoning about going through what they thought they had done in section 14 and therefore they didn't include a section 16(3) is not what Chief Justice Chaskelson was talking about in Macriniana. So, my lord, so it's a very long answer, but my answer is looking at the negotiation process in an international treaty is legitimate because the Vienna Convention on Treaties tells us so, but only as a sort of backup supplementary thing. Whether it is or not in a constitution, it's only where it's absolutely clear. Three, it's a dangerous process to get involved in, to start tracing down why a particular section was or wasn't there and how it was worded. And so I say in this case, we would prefer the living tree approach and the restrictive approach to anything that excludes rights, which is an well-established principle of constitutional interpretation, to delving into the labyrinths of constitutional negotiation.
No, I did know. I noticed in your case, you yourself referred to something about the negotiations in relation to Section 16, and I just wanted to ascertain, given the submissions you've made today, that you are accepting that there are circumstances which you've now articulated where the negotiations can be looked at.
Well, my lord, I would hesitate to say it's impossible, because even on statutes, sometimes you can look at the background. But I just say it's dangerous and it's not clear, and that the living tree doctrine is better, the purposive construction in Ray's is better, and the restrictive interpretation in Hughes is more clearly established. But and I also say that you can get quite lost if you go down that process. And so we would say it's no substitute for, should the words be interpreted in this way, given that it would exclude rights rather than confer rights. And after all, when Chief Justice Chaskelson did that in Macriniana, it was in order to liberate the court to reach its own conclusion the death penalty was unconstitutional, not in order to say that the death penalty is a jolly good idea, because the negotiators thought it was. And so with all those provisos, I think I would have to accept you can't rule it out in all circumstances.
Thank you very much.
But can I go on to the right to found a family point? Because what we say is, Section 14.1 says you have the right to marry and found a family. It's accepted that same-sex couples have a right to found a family. They don't found their right to found a family, or base their right on founding a family, on Section 14.1. And the mere fact that it's referred to in Section 14.1 doesn't make it the lex specialis. So they can look outside Section 14.1 to Section 9 for the source of their right to have a family, to found a family. So that indicates that Section 14.1 is not a comprehensive and exclusive code that disposes of all the rights that a same-sex couple may have or not have in respect of marrying and founding a family. And that proves our point. We develop it in the reply at electronic bundle pages 812 to 813. And the Court of Appeal, and indeed my learned friends, say, well, yes, of course, same-sex couples have the right to found a family, but they have that right conferred by Section 9 rather than Section 14.1. That's paragraph 99 of the Court of Appeal. Well, since they do have that right conferred by Section 9, it's clear that not all the relevant substantive rights referred to in Section 14.1 can only be derived from Section 14.1. So we say that slightly proves the point. The other point is a more complex one, but it's this, that the European Court, in the case of Goodwin, which we've dealt with in our reply at 4.6, this is in the e-bundle at 821, European. Okay. Yes, Goodwin. In the European Court, in Goodwin, recognised the right of transsexuals to marry, and that's to say of a biological male who had a gender reassignment to marry another biological male. Now, on our reading of the Constitution, because sex is defined by national law, that right would have to be denied under Caymanian law if the government's interpretation of Section 14 as the lex specialis governing the right of all citizens to access marriage is correct. And that's because the marriage of a biological male who has had gender reassignment to another biological male would be prohibited on the government's interpretation of Section 14.1. And that would bring the Caymanian law in conflict with the requirements of the European Convention itself, which, as I think we've established, would be a breach of the international obligations of the United Kingdom. See Matadine and Pointu and see Ex parte Brind, and see our written case at paragraph 616. So again, if you want to give effect to the right recognised by the European Court of a biological male who has had gender reassignment to marry another biological male, you have to go outside Section 14.1 and derive it from Section 9.1. And that's another example of how it's not a complete code that deals with all the rights that we say need to be dealt with and catered for on a proper interpretation of the Constitution as a whole.
Mr. Fitzgerald, if I may just ask you about Goodwin.
Yes,
the problem in Goodwin was that there was a failure on the part of the state to recognise the transgender person in their new gender.
Yes, yes.
And that was what the issue was in Goodwin. Now that's a different problem. And if there were a problem with Caymanian law not being compliant with the law in the European Convention, wouldn't that be the way in which one would solve that, as indeed it was solved in the United Kingdom, by recognising the transgender person in their new gender with everything that follows from that, rather than on, as I've understood your argument, in effect tinkering at the edges and saying, well, the solution has to be a change to the law in relation to marriage, rather than the law in relation to recognition of someone in a new gender.
Well, my lord, what I'm saying is there is a situation which, on the strict interpretation of Section 14.1 adopted by the government, could not be catered for. But my lord, what I do accept is that the effect of the European Court's decision was that you had to, as your lordship said, recognise the gender reassignment, and so treat the person as female for the purposes of their right to marry. I mean, that's putting it very, very crudely, but I accept that was the effect of Goodwin. But my lord, again, if one's striving for an interpretation of the Constitution that recognises the rights of the transgender woman, and if one is striving for an interpretation of the Constitution that provides for the rights of a same-sex couple to found a family, which they undoubtedly have, you have to look outside Section 14(1) to Section 9. I mean that's the point I'm seeking to make.
Yes, thank you.
But I accept your lordship's your lordship, of course, is correct about what Goodwin did decide. My lords, then that brings one to this point, that if the next point is the historical intention approach. The Court of Appeal relied on the historical intention of the drafters, and if one looks at paragraphs 95 to 96 of their judgment, they say that it was inherently unlikely that the drafters of the Constitution had only included Section 12 in its present form, I quote, in order to protect heterosexual marriage from possible future attack. And they referred to the historical position in 2009 in that same passage. We submit that the Court of Appeal's reliance on the historical intentions of the drafters is mistaken. And that's for the reasons we've set out at 8.13 of the written case at electronic bundle page 735, electronic bundle 735. Even if at the time of drafting the Constitution, there was a historic intention to exclude same-sex couples from access to marriage, the task for the court is to apply a generous and purposive interpretation to the rights under Section 9, 10 and 16, and to limit any restrictions on the development of human rights. The parallel is the case of Edwards, the Attorney General of Canada, where senators had to be he's, according to the historic context in which it was introduced. But the board developed the living tree doctrine to say you must allow for the development in accordance with evolving notions of fairness as between the sexes.
I don't know, Mr. Fitzgerald, how far you want to push this, but I mean, this point was considered in Matadine and Pointu, and Lord Hoffman says, you know, we're all familiar with strictures against tabulated legalism, but at the end of the day, we are trying to construe the words that we used, and
Yes.
the historical background is relevant to that exercise.
Yes, my lord, I accept that, but the approach that I invite the board to adopt is, in order to make sense of the Constitution as a whole and to harmonise the rights that are in tension, can one reasonably, is it reasonable to interpret Section 14(1) in a restrictive way? Can you make sense of the Constitution as a whole in that way? Can you reasonably interpret it in that way? And I do respectfully submit that if one goes back to the historic approach, then you end up with the kind of mess. Well, we know that in Lancaster House in 1960, they sat round and decided that the mandatory death penalty should be immunised from challenge and so should flogging, and therefore they wrote in these protective provisions, these ouster clauses, and no Privy Council afterwards can use any restrictive approach to those, because what matters is that they sat round in 1960 and decided that flogging should be untouched and the mandatory death penalty should be untouched. That's not been the approach of the board. The approach of the board has been to say as in Hughes, can we reasonably interpret this clause, which would otherwise restrict human rights, in a restrictive way? And in order to give effect to evolving standards of decency and developing approach. So, my lord, I accept there's a tension between it's not interpretation but divination, or whatever was said in which we hear from time to time, and give it a generous interpretation in accordance with evolving standards of decency. It may slightly depend on what part of the Constitution one's dealing with and what the norm is that one's dealing with. And I accept that, of course, when one's dealing with a prohibition on cruel and inhuman punishment, you want to give it as much, as it were, leeway to develop as possible. But I would say the same is true of the Section 16 prohibition on discrimination. It's a fundamental norm which should be given as broad and evolving a reach as possible. But my lord, I hope that the approach that I adopted in answer to my Lord Hodges' questions is a fair one about history. Yes, if you've got to, if it's clear. Yes, if it's clear, and if it doesn't defeat all possibility of evolving standards. But my lord, that's so. The reason, so there is a limit in my submission to the question of discovering the historical intentions, and I rely on the approach that we set out these points in our skeleton argument in the Court of Appeal about the intention of the drafters in some detail, and I've given you the quote from Lord Halsbury about, don't ask the draftsman, he's the last person who'll know what he's done, because he'll just say, well, this is what I intended to do, therefore I must have done it. And that is a warning over citations from Mr. Hendry's book about what they had achieved. There is one other point, and I think this is in our skeleton.
I'm so sorry, Mr. Fitzgerald, but it wasn't just the quotation from Mr. Hendry's book, was it?
No.
As I understand it, he, as the chairman of the conference that drew up the Constitution, produced a note effectively explaining what had happened at the conference itself.
Yes, no, my lord. I again, I accept that, and I don't dispute that what he describes happened. I just submit that.
I mean, it's quite common for the chairs of conferences to summarise the general tenor of the debate that has occurred at the conference, isn't it?
Yes, my lord, I accept that, but the first test, as the Chief Justice approaches, can the words be reasonably interpreted in this way? If the answer is yes, they can, applying basic doctrines, then you don't go to the negotiating process. And that's the first principle. And that's even so under treaty protection. The second test is if there's real doubt. My learned friend says there's no doubt, but if there is real doubt, then you can look at background materials. But as Chief Justice Chastelson said, it's got to be clear and beyond doubt what the position is. And we dealt with that in the skeleton in the Court of Appeal, at part 3 of that skeleton, electronic bundle pages 598 to 602. I would respectfully invite the court to have regard to that, where we dealt with, because we dealt with the fact that the drafting history can only be resorted to if there is some ambiguity to be resolved. The Chief Justice didn't think that there was. Then we say that even under the Vienna Convention, recourse to history is only a supplementary means of interpretation, where the interpretation by reference to the ordinary meaning leaves the meaning ambiguous or obscure. Thirdly, that in Macqueniana, which is relied on for the proposition that you can do it when looking at a constitution, that involved the interpretation of a foundational constitutional instrument. The words of Benyon still hold good as to the limitations and dangers of relying on enacting history. Thirdly, it's got to be clear, not in dispute, and relevant, according to Chaskerson. And we did make the point that a lot's made about the fact that this was put before the people, but the draft Constitution Explanatory Guide made no mention of the supposed exclusion of same-sex marriage. It merely stated the government could not prevent marriage between consenting opposite-sex couples, and we've set that out. And we say that at best the negotiation history shows that Mr. Henry noted that at that point in history, the European Court's approach to Article 12 was that it provided no right to same-sex couples to access the institution of marriage. And he made that statement prior to Schalken Kopf. Anyway, we've set it out in that so in some length.
And can you give us the electronic bundle reference to the note of Mr. Hendry's, which is referred to, I think, in paragraph 91 by the Court of Appeal?
Yes, I will be able to. It's
paragraph 90.
Paragraph 90. Mr. Hendry's
paragraph 90 of the Court of Appeal refers to Mr. Hendry's note.
Yes.
And I was asking for the electronic bundle number.
I think it's right at the back. Hang on. It's is it volume 10? Yes, it's tab 106, my lord. And the electronic, yes, tab 106. It's at 4488.
Thank you very much.
That's his commentary, if that's what my lord. Yeah, so I'm sorry, my learned friend is indicating.
Yes, my lord, that's not the correct reference. The correct reference is to the transcript of the third round negotiations. Oh. It's at page 503, and your lordship will see that the extract is in internal page 127.
Thank you very much.
So I'm so sorry, I'm referring to his article describing the history. Okay, yes. My lords, the next argument is about section 16.7. I think I've really summarized that point, which is set out in our reply at part 4, pages 819 to 823. And that is that you can still apply the provisions of section 16.1 and section 16.7 read together to any law passed in compliance with section 14.1. And we do rely on that. And we say that if you apply that test, the restriction that's contained in section 2 of the Marriage Act may comply with the requirements of section 14, but when tested against the requirements of section 16.7b, it's not a provision or restriction that is reasonably justifiable in a democratic society. And as to reasonably justifiable in a democratic society, the test, we say, is one of strict scrutiny, given the importance of the right affected. The authority for that is Steinfeld, paragraph 28, pages 1600 of e-bundles to 1601. Public opinion, even as expressed in a legislative majority, is not a justification for the denial of the right of a disadvantaged minority. That's the authority for that is Reyes, Lord Bingham, at paragraph 26, which is in the electronic bundle at 1529 to 1530. And thirdly, the Chief Justice himself conducted the justification exercise and concluded that the discrimination was not justified by any legitimate aim and was not proportionate. And as he found, the state could no more deny same-sex marriage than it could deny interracial marriage. That's at EB pages 115 to 116, paragraph 320. In the Court of Appeal, we set out our submissions on justification at length at pages 549 to 551. But I think I've taken the board through the exercise that the Chief Justice conducted from EB page 107 to EB 117, testing whether it could be justified on grounds of public morality and concluding it couldn't, whether it was objective and reasonable, concluding it wasn't, and concluding that there was no proportionality or fair balance given the impact of the discrimination on the appellants.
Mr. Fitzgerald, I'm sorry to interrupt you, but if Miss Rose will forgive me, I think the passage that you had in mind is actually in the book by Ian Hendry and Susan Dixon. I think
Yes.
I found it at electronic 4494 to 5.
Yes.
The foot of 4494 were told the last paragraph, the most controversial provision for each of the
Yes.
territories is the right to marry, because they're unanimously opposed to same-sex marriages and marriages involving a transsexual, marrying a person of the birth sex and transsexual. Then reference to the case law of the European Court of Human Rights, and then the concern that
Yes.
that doesn't provide a clear enough steer, and therefore additional wording was agreed during the negotiations. And we're told first of all about the British Virgin Islands, and then just at the top of the next page, the Cayman Islands.
Yes.
With section 14.
Yeah. That was the passage I was thinking of, my lord. Yes. In his yes. Yes. My lord, I'm obliged. My lord,
Sorry.
perhaps I can, because I've got 5 minutes to go. Can I just try and finish?
Right.
And unless you want to give me extra time. My lord, I've got to deal with 2 further questions. The question of remedies, and that's in our reply. We develop it in our reply at part 5. In the electronic bundle at 823 to 826. In short, we say this is an existing law, and existing laws can be modified, or must be modified, whereas post-constitution laws are only subject to a declaration of incompatibility. But this was an existing law, and there's a very well-established jurisprudence of the board in the series of cases cited by the Chief Justice from paragraph 369 onwards, Rudall, Mollison, Reyes, Orozco, that when it's an existing law, you modify it, and it only continues in existence as modified. So that's not a case for a declaration of incompatibility. And we've set out that argument fully in our paragraphs 129 to 145 of our case, and at part 5 of our reply at 823 to 826. So we say this is not a case for a declaration of incompatibility. This is an existing law, and we've set out the stages that the court has to go through in our reply, electronic bundle page 823. Yes, 823. That section page 824, section 23(1) applies only to primary legislation. That's the deal with where you only have a declaration of incompatibility. That term is defined as a law enacted by the legislature. The legislature is that established by the Constitution. So it's the body that comes into being after the Constitution. As such, the Section 23 power to make a declaration of incompatibility arises only in respect of legislation enacted after the Constitution came into force. Therefore, the courts have no power to issue a Section 23 declaration of incompatibility regarding such existing laws, and they rely on the provisions subject to this section. The existing laws shall have effect on and after the appointment, as if they'd been made in pursuance of the Constitution. But the section goes on, and shall be read and construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution. So you modify first, and then you continue the existence. And that modification exercise was conducted in the case of Cherisola, the Gibraltar case, which we've set out at 5.7. My lords and my lady, those are the submissions we make. I'm sorry to rush slightly with that point, but it is set out in full in our reply. There's just one short point about costs. We accept that the question of the Chief Justice ordered damages to be assessed, but because his order was set aside, that was set aside. We accept that that issue could be dealt with subsequently. That's to say, the violation of the right for recognition of their relationship by way of civil partnership or something like that could be dealt with by a separate action for damages, even if the judgment of the Chief Justice were set aside. We do respectfully submit in relation to costs that we put our point on 9.1 of the written case. It's unusual to order costs against parties to a constitutional case, but in the Grand Court, where this is solely concerned with the costs of the Grand Court, we do respectfully submit that if one looks at the history, there was no acceptance of the right, even for a civil partnership type arrangement, 5 years after Oliari. The appellants had to go to court to vindicate even that right, and it was not actually finally accepted until the Court of Appeal hearing that declaration was final and effective. So we do respectfully submit that the costs of the Grand Court, which were that hearing was necessary in order to establish the entitlement to civil partnership on the basis of the Oliari judgment, should be awarded to the appellants, whatever the position is as to, as it were, there was a draw in the Court of Appeal, because in the Court of Appeal, the Court of Appeal again had to issue a fresh declaration, which was finally given effect to, about civil partnership. But it's right that we lost on marriage. So we would respectfully submit that as a matter of principle, it would be right that the appellant should have the costs of the Grand Court hearing, and that there should be no order for costs as there was in the Court of Appeal. My lords, my ladies, those are my submissions, unless I can assist the board on any further points.
In relation to costs, there will of course be an opportunity for written submissions on costs in the light of whatever judgment we
Yes.
give to you in this case. But thank you very much, Mr. Fitzgerald. I think before we turn to you, Ms. Rose, we'll take the opportunity to discuss amongst ourselves what we've heard and what we need to hear you on. If you remain, you and Mr. Fitzgerald remain where you are, the five of us will go into a private meeting.
Oh, yes. My lord,
Yes,
will we have 5 minutes for a comfort break then?
yes, certainly.
Oh, thank you. Okay, thank you.
I think we're ready to resume. Ms. Rose, we would like to hear you on all points. We would particularly appreciate analysis of the lex specialis or generalis specialibus point, and also analysis of the relevance of the historical background or travaux préparatoires. And in relation to both points, we're by now pretty familiar with the common law jurisdictions other than the board and the Privy Council jurisdictions. But for example, the United States and South Africa, we're pretty familiar with that material now, and also with the more general statements in some of the Privy Council cases, like Ray's paragraph 26 and the well-known passage in Matadine. But there may be other material in the case law which bears more directly on the relevance of historical background, and also, as I say, we'd appreciate analysis of the lex specialis point. But you should answer on all the points that have been raised by Mr. Fitzgerald.
I'm grateful for that indication, my lord. Before I start, can I just pick up one point about Mr. Hendry?
Yes.
If the court goes to the electronic bundle, page 166, this is the judgment of the Court of Appeal. And you can see that there are two references to Mr. Hendry. If you go back to the preceding page 165 at the bottom, paragraph 90, you see the heading, the negotiations leading up to the adoption of the Constitution. And there is a quote from Mr. Hendry at the end of paragraph 90, where it says, Mr. Hendry is recorded in a note as saying, marriage is so defined in this text without peradventure that marriage can only be between an unmarried man and an unmarried woman. It can't be anything else. That is the reference which I understood my Lord Sales to be asking about. And that is the reference that I gave him. That comes from the third round of the negotiations of the Constitution. And the transcript of those negotiations is at the page reference I gave to Lord Sales earlier. Subsequently, Mr. Hendry wrote a book about British overseas territories law. And the reference that your lordship was picking up, you can see is set out in full at paragraph 92 of the Court of Appeal's judgment on the same page.
Can I just check with you, Ms. Rose?
Yes.
The reference you gave us earlier
Yes.
was to page 503, if I noted it correctly.
No, my lord, I think it was, sorry, I beg your pardon. Yes, my lord, it was page 503 and internal page 127.
Yes, I've got that. And this seems to be the evidence given by Pastor O'Connor.
No, my lord. You can see at the bottom of 126, there's a reference to the chairman. And his comments go right through 127.
Oh, yes, I see. Yes, thank you.
Yes. And then Pastor Ebanks takes it up.
Yes.
Yes, my lord, Lord Sales.
Yes, Mr. Rose, do we have anywhere in the bundles or the evidence an account of the negotiations? Because page 503 is, and I make no criticism, it's an excerpt from a much longer document, and you've told us that was the third round of negotiations. Where can one get a description of what happened in the negotiations?
My lord, there's a brief summary at page 473, which was prepared for the purposes of the Court of Appeal. And the documents that are behind page 473 are the materials that were put in to support that brief summary. And you can see there's reference there to the parties who are negotiating and to the 3 rounds of negotiation. For example, if you go to 477, you can see on that page the various delegations are identified. So you've got one from the United Kingdom, one from the Cayman Islands, one from the government of the Cayman Islands, the government backbench, the opposition, then the Cayman Ministers Association, the Seventh-day Adventists, the Chamber of Commerce, and the Human Rights Committee. So there you can see all the various parties who are involved in the negotiations.
And could I just ask about the text then? Was that drawn up by, I don't know, a secretariat working with Mr. Hendry and then put to the negotiating conference? How did it work?
My lord, I will take instruction on that overnight and give you an answer in the morning. I don't know the answer to that off the top of my head.
Thank you very much.
So coming back to the beginning, my lords, my ladies, as the court knows, there are 2 issues in this appeal, which are set out in the Statement of Facts and Issues at page 690. And the first is whether the Bill of Rights affords to the appellants the right to access the institution of marriage. In other words, does it include a right for a same-sex couple to marry each other? Now, Mr. Fitzgerald has sought to draw a distinction between those 2 formulations of the issue. In my submission, they mean exactly the same thing. But I'll come back to that in more detail. The second question is the question which arises only if Mr. Fitzgerald succeeds on the first issue, and that is what relief ought to be granted, whether Section 2 of the Marriage Act ought to be modified so as to comply with the Constitution, or whether instead there should be a declaration of incompatibility. And most of my submissions will be focused on the first of those 2 issues. And our submission, in summary, is that the Court of Appeal was correct for the reasons that it gave. It's apparent from the way that the first issue is framed in the Statement of Facts and Issues that this is a question of construction of the Bill of Rights. The interpretation, does it or does it not include this right? I emphasize that this case is not about the justification for any interference with a right. The question is whether, properly interpreted, there is any right to same-sex couples to marry at all under the Bill of Rights. Our submission is that the Bill of Rights does not afford the appellants the right to access marriage because the constitutional right to marriage, which is there set out, applies only on the conditions that are laid down at section 14(1). Those conditions include a condition that the parties are of marriageable age as defined in national law, that they are not already married, in other words, that it's not a polygamous marriage, and that the marriage is between 2 people of the opposite sex. In our submission, given the inclusion of that clear and specific provision addressing the right to marry, no wider right to marry that does not include these 3 conditions can be derived from other more general provisions of the Bill of Rights, such as the right to respect for private and family life, or the right not to suffer discrimination in relation to any right. We submit that what the Bill of Rights is doing is striking a balance on an issue which was and which remains a matter of significant political and cultural sensitivity in the Cayman Islands. The Bill of Rights includes a right to respect for private and family life, which, as the Court of Appeal has now declared, requires legal recognition and protection to be given to same-sex relationships. But it does not entrench a constitutional right to same-sex marriage. The question whether, and if so when, same-sex marriage should be introduced into the Cayman Islands is a matter which the Bill of Rights has left to Parliament. That choice in our submission, and indeed I don't understand this to be in dispute, is fully compatible with the Cayman Islands' international human rights obligations, both under the European Convention on Human Rights and under the ICCPR. It is a choice that the Cayman Islands was entitled to make, and did make, as an autonomous parliamentary democracy exercising its right to self-determination in domestic matters. And we submit it would be wrong for this court to overturn it. I propose to proceed as follows. First, I'm going to consider the principles of law that apply to the interpretation of the Bill of Rights. Secondly, I'm going to apply those principles and make submissions on its proper interpretation, first by consideration of the language of Section 14 and of the Bill of Rights as a whole. Secondly, consideration of the similar language used in the European Convention and the ICCPR as interpreted by international courts in many decisions. And finally, in relation to the negotiating history, which predated the implementation of the Bill of Rights. And finally, I'm going to respond to the various arguments that have been mounted by Mr. Fitzgerald in his written case and today in support of the appeal. So coming first to the general principles of constitutional interpretation, there are 3 points, no, I beg your pardon, 4 points in particular that I want to consider. The first is, in general, the correct approach to the interpretation of a constitution. The second is the importance of reading a constitution as a whole. The third is the living tree principle. And the fourth is the principle that a restrictive interpretation should be adopted to provisions that exclude or restrict fundamental rights. Courts, and in particular this board, have made it clear on many occasions that the task of interpreting a constitution is different from the task of interpreting commercial contracts or other types of legal documents, because of the very different context and purpose of a constitution. Nevertheless, courts and this board have also emphasized on a number of occasions that the task remains one of interpretation and not of substitution or divination. The leading authorities on the topic were summarized by the Court of Appeal below at paragraphs 29 to 40, and that's pages 143 to 148. I want to look at what was said on this topic, in particular by Lord Bingham and Lord Hoffman. So can we turn first to the case of Rays at tab 20, 1518. And I bear in mind what my Lord Reid has said to me about your familiarity with the general principles in this case. And as the court knows, the key passages are paragraphs 25 to 28, which you have in the bundle at 1528 to 1530. Now, there are 4 points in particular that we seek to derive from these key passages. The first is that the issue is one of interpretation. The court must interpret the Constitution in order to determine whether the enacted law, in this case, the Marriage Act, is inconsistent with it. Secondly, in order to do that, the court must carefully consider the language that has been used. A generous and purposive construction should indeed be given to that language, but the court has no license to read into a constitution its own predilections and moral standards. The constitution means what it means. It doesn't mean what we would like it to mean or think it should mean. The third principle, and this is at paragraph 27, is that it is relevant to consider the international law obligations of the state, including, for example, obligations under the European Convention, and the question of whether the Constitution is compatible with such fundamental rights. And the starting point is an assumption that states do not intend to fail to honour these obligations. And the fourth point at paragraph 28, it is open to the people of any country to lay down the rules by which they wish their state to be governed, and they are not bound to give effect in their constitution to norms and standards accepted elsewhere, perhaps in very different societies. But the courts will not be astute to find that a constitution fails to conform with international standards of humanity and individual right, unless it's clear on a proper interpretation of the constitution that it does. Now, we say that that is a beautifully, with respect, beautifully, elegantly expressed encapsulation of the task for the court. And it demonstrates, with respect to Mr. Fitzgerald, one place where his submissions go too far. Because it is common ground in this case that the Cayman Constitution does indeed comply with the international obligations of the Cayman Islands under the European Convention of Human Rights and under the ICCPR. At one point in his submissions, I thought I understood Mr. Fitzgerald to be criticizing the case law of the European Court of Human Rights and saying that they had misunderstood the significance of the use of the phrase women and men based on an argument by a sociologist which was produced yesterday. Now, whether or not Mr. Johnson, who's the author of that article, did or didn't correctly research the travaux préparatoires for the Universal Declaration, I know not, because this article was only produced yesterday. But in our submission, that matter is irrelevant, because this is an issue that has been considered by the European Court of Human Rights on multiple occasions. And recently, the most recent decision before this court is from December 2017 and became final in March 2018. And throughout the whole of the period, in fact, we have case law that starts in 1985 and goes right up to the end of 2017. The position of the European Court of Human Rights has been absolutely consistent. It has absolutely consistently said that Article 12 is the lex specialis on marriage, that you don't derive rights to marry from any other convention article, and that Article 12 only envisages marriage between individuals of the opposite sex. So there is no inconsistency between the Constitution of the Caymans, as the Court of Appeal interpreted it, and the European Convention on Human Rights, or indeed the ICCPR. In that situation, we submit that the submission made by Mr. Fitzgerald that a restrictive interpretation should be adopted to Section 14 in order to avoid restrictions on human rights is misconceived. Because the one thing that we know about Section 14 is that it is not narrower than the rights bestowed by the European Convention on Human Rights or the ICCPR. Mr. Fitzgerald's complaint is that there are other constitutions in other jurisdictions, such as the United States, South Africa, and Canada in particular, which contain a wider right to equal treatment, a freestanding right to equality, which is not classically and famously included in the European Convention, and which is not included in this Constitution. and that those freestanding rights to equality have been construed as the basis for a right to same-sex marriage. But that, with respect, takes you straight to what Lord Bingham says at paragraph 28, that it's open to different societies to decide to adopt different types of constitutions. Both types of constitutions comply with international human rights norms. They are simply different types of provision. To give another example, there are constitutions and indeed international human rights instruments, and the Inter-American Convention is one, which permit capital punishment. The European Convention on Human Rights has a protocol which prohibits capital punishment. That's a good example of a situation where different regions have adopted different approaches. So that is Ray's, and I then want to turn to Lord Hoffman in the case of Matadine and Pointu. And this is at page 3300. It's tab 77 for anybody using a hard copy bundle. Now, Matadine and Pointu is a case which is often cited for one paragraph. In fact, there are two paragraphs of Matadine and Pointu that have achieved a level of fame. But in fact, when you look at the case in more detail, in my submission, it has a greater significance and relevance for this case than you would assume purely from looking at its headline points. My lords, I'm aware of the time, and I do want to take a little time with Matadine and Pointu. It's important to my argument. Can I suggest that we make a fresh start with it at 10:30 tomorrow morning?
Yes, I think that's a good idea, if I may say so. Thank you then. We'll adjourn and resume at 10:30 tomorrow morning. Thank you.